Hi, everybody. My name is Chris of National Parents Organization, and today I'm here with Achish Joshi. He's an attorney and recently gave a speech at a conference, and we'd love to hear more about what he had to say because his conference talk was about how to tell the story in the courtroom, which I think is really important. I think a lot of people underestimate how important a good story is in the courtroom. So thanks for visiting us today. Tell us a little bit, what makes a good story in the courtroom?
Thank you, Chris. Pleasure to be here. My presentation that you spoke about was at the Toronto conference that focused on the storytelling aspect rather than getting consumed by expert evidence, scientific evidence, and all of that, which no doubt is important. But we forget that judges, human beings, and at the end of the day, they have to be persuaded about a certain cause of action. Just a little background about myself. I'm an attorney based out of Ann Arbor, Michigan. My practice focuses on cases involving family violence. So, by family violence, I would include things like domestic violence, intimate partner violence, parental alienation, coercive controlling behaviors, emotional abuse, and all of that. That becomes the broad spectrum of family violence. I litigate these cases around the country and internationally. So I do trials, I show up in court as a lawyer for one parent or the other. Sometimes I'm appointed as a guardian ad litem for the children by a judge. And in my experience in doing these cases around the country, I realized that lawyers often get bogged down on science issues. They get so focused on expert evidence and getting a certain expert before the judge or challenging the other expert that they fail to tell the story. What exactly it is that their client, whether mom or dad, what do they want from the judge? What do the children need? At the end of the day, when you're talking about abuse, whether it's physical abuse, emotional abuse, psychological abuse, or even at times sexually abusive behaviors, we are talking about human behaviors. That's where the spotlight needs to be on. Of course, you can have science support your argument about behaviors, but at the end of the day, no expert is going to save the day for you if your client, the mom or dad, comes across not credible. So you have to have that human angle to your story, and you have to put enormous effort into making sure the story is persuasive, the story is credible, and the story resonates with the trier of fact, which usually in this cases is a judge. Some jurisdictions, such as Texas, for example, does have jury trials, but by far, most often, it's a judge, one single human being that makes a decision on issues of custody and parenting time.
So yeah, I think a lot of people really forget that, judges are human too, and persuading a person is can be very difficult. What's the difference between a good story and just presenting the facts? What have you seen that work out in real life?
Well, let me give you an example about parental alienation. Parental alienation, just to simplify it, and from a simplistic level, we are talking about a phenomenon where one parent has poisoned the child against the other parent. We are talking about a situation where, let's say, the father, the dad, is the alienating parent. The dad basically brainwashes and programs the child to reject the mom. The dad keeps on talking inappropriate things to the child, keeps on sharing inappropriate information with the child, which leads the child to question the mother's love for the child, whether the mom is a fit parent, whether mom is safe, whether mom deserves the child's love and affection, and all of that. So that phenomenon is parental alienation. It's too easy to get bogged down into all the science, all the research studies, getting the top expert from a top university to talk about how this is emotionally abusive, what are the research studies that show effects of alienation, how do you measure alienation if you can measure it at all? How do you find alienation to be a part of a case or not? These efforts sometimes just take over the entire trial. So you might have days of expert testimony and very little time left for your client, the mom or dad, to get on the stand and talk about their life. What is it like to be a parent of a child who's being alienated? How does it feel when your child comes to you and says, I hate you, mom. I hate you, dad. I wish I was never born. How does it feel to get rejected by your flesh and blood? What are the challenges involved in parenting such a child? How do you manage co parenting with the other parent? These are the issues that need super focus on. You need the judge to realize what it is to be in your shoes because no one is perfect. And in these cases, sometimes the parent who's being rejected has made some poor choices. You often see a parent who's being rejected lash out on the social media, for example, write about how family judges are corrupt, court system is really broken down. The other parent is abusive. They write angry text messages to the other parent. Sometimes they yell and scream at the children or the child as well for being defiant, rude, all that things. You have to help the judge walk in your shoes. You have to explain to a judge what is it to be in your shoes. A day in the life of a rejected parent. And that takes time. It takes effort. Sometimes you are able to show some videos of recordings where the children have been saying horrible things. You can show some of the testimony by text messages or video recordings or audio recordings, but it has to be a compelling story. People get focused on getting some clinical interventions, and it does help. But at the end of the day, the judge needs to understand that you are trying to help your child. You are not just fighting for quote unquote your custody. You are fighting to have your relationship with your child to be protected by the court. You are fighting to keep your child away from emotional abuse. That little zombie who keeps on screaming at you hateful words actually loves you, and you want to try to show the court that at the end of the day this child will settle down if the court gives you the tools to help you and the child with. Once the judge realizes that A, the parent is fit and loving parent, the parent is good enough parent, and that's important because in this struggle we sometimes forget that you have to be a good enough dad or good enough mom. You don't have to be a perfect dad, you don't have to be a perfect mom. Everyone's human, but you just should be good enough for that. The court has to trust you that you're going to do the right thing if the court gives you the power, full custody or parenting time, or authority to make decisions for your child. Once you get that connection, once you are able to have the judge look at your case from that vantage point, then expert evidence makes sense. And that's icing on the cake, according to me. You can't substitute expert evidence for the fact evidence. It always aids the court into understanding more of the dynamic that's at play here.
So, in telling the story, you really have to get the judge to almost sympathize a little bit with you. And I think a lot of times we lay people, especially, will consume media. And it's much harder to tell a story, I think, than people realize. But what are some things that people can do in telling their story to make sure that the judge empathizes with them?
Well, every judge is different. So that's the first thing. And it's important to study your jurisdiction. The arguments that may work before a judge in, let's say, Chicago may not really work if you are in a rural jurisdiction in Indiana or Georgia. So you have to put some effort into finding out who your audience is. Does your judge come from a background of being a prosecutor? Does your judge come from a background of being a defense lawyer? Does the judge come from a background of having practiced family law? Is the judge that conversant and skilled in understanding of science in this area? Has this judge made any presentations before other judges on these issues? So you try to first find out more about your audience, and then you look at your facts. I sometimes find that what lawyers do is to first focus on a theory. Let's say they call it parental alienation or child psychological abuse, and they put the theory before the court, and then they go in search of facts to support the theory. It should be the other way around. You look at the facts of your case, you look at the evidence that you have, you're going to present before the court, you interview the witnesses that you're going to call to the court, whether there are police officers, child protective service workers, school teachers, neighbors. You look at the whole situation, the whole story, the pattern, and then think about what's the best way to put it before the court. And these days, you often get one day here and one day there. Sometimes it's by Zoom or video as well. So you're not going to be as effective if the trial is going to be broken up, which always happens in these cases because very rarely a court's going to say, I have 2 weeks set aside for you. So you have to figure out who is your most compelling witness. If you are alleging that the father is the abusive parent and the father is interfering with the mother's custodial rights, then you have to demonstrate that to the court. You have to have your client, the mother, take the stand and explain what has been going on. You have to pick and choose some of the most compelling pieces of evidence that you have and use them early on into the case so that the trier of fact, the judge, is hooked on and is more interested in that.
Yeah, that makes a lot of sense. What are some other mistakes that people make when trying to tell their story?
One of the mistakes that I often see people making is to avoid a trial. You often see in these cases that the lawyers and their clients will file paperwork. They're called motions. They'll file a motion for change custody, motion for more parenting time, motion accusing other parent of being a bad parent, claiming parental alienation or abuse or whatnot, but they shy away from trying the case. And what happens is, over a period of time, the judge is just inundated with all these paper filings, but there are no judicial filings, or there are no judicial findings. It's one thing to allege something in court, and it's totally a different thing to make a judge make judicial findings. So don't shy away from having a trial or an evidentiary hearing. If you believe that your client is not being an abusive parent, but rather interfering with the other parent's parenting time because she or he is being a protective parent, the other parent has maybe substance abuse issues, drug abuse issues, or is just not a fit or stable parent, and you are being accused of alienation, let's say, you need to go to the court and explain, take the stand, and testify under oath. The judge needs to make some findings. Otherwise, you are going to be filing paper, other side's going to filing paper, there are no findings. People make deals in the hallway, and 6, 7 months go by, and you are back at square one. Same issue. And children age out when that happens. A lot of people talk about how we should avoid litigation because it's not in the child's best interests. And that may be true in many cases, but that does not hold true in cases where allegations of abuse are being made. Because either a parent is being abusive or the parent is being protective. There could be several things in between, but I'm just making it a simplistic or for the argument. But whatever it is, you need the court to make a finding, because once you have a finding, whether it's a finding of alienating behavior being present in a case or a finding that refutes the allegation of alienation, then that's helpful. That is helpful for the court. That is helpful for the parties to understand that, but it's also helpful for the therapists, for the clinicians who are going to work with the family. So a clinician now knows that, okay, this is a judicial finding that I have to work with. So and so parent is being protective, or so and so parent is not being protective. And then they can shape the therapy accordingly. Otherwise, people have their own ideas, they have their own allegations, there's no meeting of minds, there are no findings that people can agree on. That's one of the most common mistakes I find of lawyers and parties shying away from litigation and avoiding going to trial.
Do you find, when trying to tell the story, do you try and focus on more the parent experience or the child experience, or do you like a mix of both?
A mix of both. A child's experience is always a complicated issue, depending on the age of the child. In family courts, generally speaking, children don't get to testify, but the children's voice is being heard by the court, either by the judge interviewing the child in chambers and trying to get the child's preference about custodial and parenting time issues, or sometimes the courts appoint what is called minors counsel or guardian ad litem or an attorney for the child, and they put forward the child's preference before the court. So that is always considered in most circumstances. But you need to put the parent's perspective as well before the court. And that's what driving this litigation in most cases. Judges sometimes get conflicting filings. Mom wants full custody, dad wants full custody. Who is a better parent here? Who can be relied upon to make the decisions in the best interest of the child? Is one parent a safe parent, a more fit parent? Is the other parent so consumed by the hatred over the others that they are going to forget about the child? So these situations need to be explored, because at the end of the day, a judge has to decide who is more credible, which narrative makes more sense, who is more likely to tame down litigation, who is more likely to settle down and focus on the child here. And they have to weigh all those facts and then come back with a decision. I've had situations and I've seen cases where the judges get so frustrated by the parents fighting at each other and at each other's throats. They sometimes say, none of you deserve this children. I would be better off putting these kids in foster care. I mean, you guys are so consumed by your hostility towards each other and anger toward each other that the children are suffering. Sometimes people are tone deaf. I mean, they are so consumed by their desire and by their tenacity to prove certain thing, whether it's parental alienation or domestic violence or whatever it is, that they just don't hear the court coming across them and they are tone deaf at times.
What are some tips that you give folks that have to go up and testify in court on the stand when telling their story? Are there sort of some best practices that you like to guide them with?
I usually like to talk to my clients about what to expect. It's a very unnatural experience in some ways. You get on the stand and you're asked some questions about what do you do for a living, where do you live, and things like that. It's not a natural conversation, although that's what it should be. You are aiming for a natural conversation that people can follow through. So you have to understand what is it that you're going to be asked in the court. Are you going to be asked about certain documents? Are you going to be asked about certain incidents? How much detail should you give? How much time do you have? I mean, often what happens in this case is that because of the focus being on the science and the experts, everyone's just waiting for the great experts to come in. And then someone's available, someone's not. So the court says, well, we have Dr. So-and-so coming in at 11 a.m., but here we are starting at 9:30 a.m. Why don't you put that on for an hour or so? Let's take the testimony and then we'll look at that expert. So you put the party on for 1.5 hours or 1 hour, then you take a break in between, put the expert on, put the dad back on, and that chops up the testimony. There is no flow there. So you have to figure out what is the best time to put your client on the stand and what is the best way to draw the judge in so that the court's going to pay attention to your narrative and the story in issue. And you have to work on the exhibits. Exhibits are important. I mean, this day and age, a good photograph or a good video could be enormously helpful. It's one thing for a parent to tell a judge what it's like to be rejected by your flesh and blood. But when you actually play that 40-second video and the judge could see the dynamic between you and the child, or the judge could see, for example, the other parent talking really bad stuff to the child about the targeted parent, it makes sense. Then the judge could see where the resistance is coming from. I mean, I've seen sometimes horrible exchange videos, where mom and dad exchange the kids for the weekend or whatnot. And one parent is just saying really nasty things about the other parent in front of the child. But you have to exercise some judgment. You have to figure out, is this going to advance the theory of your case? Does it really help? I don't think you should use a video just to make a point about the other parent. There are several cases where people trying to use videos, that things are backfired because the court saw, well, were you so busy collecting evidence that you forgot to parent your kid? I mean, are you trying to be a parent or are you trying to be a detective here? What are you doing when your child is acting out? So you have to look at it and you have to show some deliberation, think about it, but then pick your best parts of your case that's going to advance your storytelling.
What are some of the biggest mistakes you could make when trying to tell your story to the court?
Oh, that's a great question.
I'm sure you've probably seen lots of examples. It might be hard to boil it down.
Yeah, I think it's the biggest mistake is to forget who your audience is. You have to pay attention about your audience, the family court judge. If you have a judge who is more conservative, then certain things are going to be more persuasive to the judge than others. If you have a judge who is coming in from a prosecutorial background, then evidence about abusive behaviors, domestic violence, things like that may be put in the forefront. So you have to listen to the audience and you have to pay even more attention to the comments or the objections that are being sustained by the court. I've seen sometimes, even though the court says, counsel, I don't find that to be relevant, the lawyer is so focused on proving his or her case that they just keep on going and are not paying attention as to how it's affecting the court. So you have to take a look at it. Is this persuasive? Is it not? And you have to be quick on your feet. You may have to change your strategy. You may have to change the order of your witnesses. You may have to invite some questions from the court as well. I mean, good judges often have questions of their own. So you have to pay attention as to what is this judge going to look for? What is he or she trying to get out of a witness? And that tells you what's important to them. Because that's what matters. It doesn't really matter as to what's important to you or your client. I mean, of course, it matters in some sense, but it's even more important to figure out what is going to matter to this judge. To get the judge to help you, you help to help him or her.
Yeah, that makes sense. We're getting kind of close on time here. Do you have any final thoughts?
No, I think those were the great questions. I mean, your members or people who watch your show, I mean, they can go to my website. It's www.joshiattorneys.com. And I have a lot of stuff on the resources. There are a lot of articles they're published. They're all free. They can be downloaded. They can read about it. And family violence is a very sensitive topic. Emotions are running high. You are so caught up in the minutiae of things that sometimes it's easy to ignore the big picture. So you have to take a look at the big picture as well and think about, does my story make sense? Is it persuasive? Is it credible? Then you have to ask those hard questions to yourself.
Well, fantastic. And you do work nationwide, or what area can people contact you for work?
I practice around the country, but in America, lawyers have to be licensed in certain jurisdictions. So my primary licenses are in Michigan, New York, Washington, D.C., and some federal jurisdictions. But I practice around the country. So what happens is that, let's say I have a case in California. The local lawyer in California tries to get me admitted into the case as co-counsel. So I come in for a particular part of the case. I might cross-examine the custody evaluator, for example. I might cross-examine an expert or put an expert on the stand. I might examine the client on the stand. So I have a limited but very well-defined role in these cases. But that doesn't mean that I would practice in California for every other case. It's a specific permission that is given by the court for specific cases.
Okay, excellent. We'll put the link to your website in the comments down below on the video. And anything else before we leave? Thank you so much for coming. We've really enjoyed hearing this, and it's really great that you have the resources on your website. I think a lot of times this stuff can be a little ominous and a little bit hard to find information about. So it's really great anytime we find a resource like that.
Thank you. I don't have anything further. I think you asked all the right questions and we got it out then.
All right, Joshi, thank you so much. And we will post this and look forward to hearing everybody's comments. Thanks so much.
Thank you.